877-381-3811. There's a very, very important article at Conservative Review. And you can go to conservativereview.com by our buddy Daniel Horowitz. And the title of this piece is Obama's Third Term. 13 times federal courts said Trump must continue Obama's lawless policies. And with the runaway train of judicial supremacy consuming our political system, do elections really matter? He asks. Anyone who has his head above the sand should recognize by now that the unelected judiciary, what was supposed to be the weakest branch of government, has been accorded the status of sole and final arbiter of every social and political question in recent years, which is why I hope you watched on Sunday Life, Liberty, and Levin. Dr. Coburn, former senator from Oklahoma, Mark Meckler, who runs the Convention of States organization, and our rather extensive discussion about Article 5 Convention of States, because that's really the only way out of this. But there is a subset of this judiciary that is particularly disturbing. In addition to overstepping their jurisdiction, ignoring the Constitution, and abusing the rules of standing, courts are now using Obama's discretionary executive policies, many of which were lawless, as a new legal baseline, thereby prohibiting Trump from merely reverting back to the way things were before Obama unilaterally changed the law. Here are 13 examples. Ready? Executive amnesty. This must be on the top of anyone's list. Obama's unilateral violation of American sovereignty and immigration law was likely the most lawless act of an executive in recent memory. But when Trump simply countermanded that usurpation, a number of district judges, from William Alsop and Nicholas Garforus to John Bates, said he must continue issuing work permits and visas to people who, under the law, must be deported. Shockingly, the United States Supreme Court refused to grant the government an expedited appeal, despite the unprecedented circumstances, forcing the administration to first go through the crazy Ninth Circuit. Number 2 example, the president's set refugee levels except for Trump. The law, 8 U.S.C. Section 1157A2, grants the president full authority to set the circumstances and numbers of refugees, yet several district judges, including Theodore Chong of Maryland, ruled that Trump must continue the refugee policies of Obama. Evidently, only Democrat presidents can set the refugee cap. Unfortunately, the administration gave in to these courts and modified the refugee provisions of the so-called travel ban, so this issue never had its day in the Supreme Court. Third example of judicial oligarchy. Temporary immigration status is really permanent. Temporary protected status, TPS, is designed to afford temporary residence to those here legally, while a natural disaster happens to take place in their countries. Contrary to statute, Bush and Obama extended it to illegal aliens and made it permanent for many countries. Trump merely followed the statute and made this status temporary. Yet Judge Denise Casper said that because Trump is a racist, a word temporary in the statute really means permanent. Example 4 of our judicial oligarchs, catch and release of bogus asylum seekers. Obama not only expanded the definition of asylum, but began releasing even adults who came here as bogus asylum seekers. Judge Dana Sabraw mandated that Trump continue catch and release. Additionally, in July, James E. Bogsberg, federal judge in the D.C. District, certified an entire class of Central American asylum seekers to lodge an injunction against 5 ICE officers for not continuing another Obama policy of granting parole to aliens who pass the credible fear test. Bogsberg is also a member of the lawless FISA court. Example 5 of judicial oligarchy. Obama's visa programs are now the law. One of the many immigration programs Obama concocted by administrative fiat was a program to allow foreign entrepreneurs to circumvent the visa process and apply directly for parole. Trump respected the fact that only Congress can create this program and merely discontinued it. But Judge Boasberg once again ruled last December that he must continue it. Number 6, take the census, but don't find out who's a citizen. In July, Judge Jesse Furman indicated during oral arguments he would side with the liberal states suing the Department of Commerce for adding a citizenship question on the 2020 census form. Granted, it was not just Obama who stopped asking these all-important questions, but the question was asked from the founding on up through the 1950s. But Trump can't simply restore this common sense practice, says the judge. Number 7, Trump must continue Obama's contraception mandate. Last December, Judge Wendy Beetlestone ruled that the Trump administration must continue enforcing the Obama-era contraception mandate, forcing employers to directly or indirectly provide contraception as part of their mandated insurance benefits for their employees. The Supreme Court already invalidated Obama's mandate in the Hobby Lobby case, yet Obama found a way around it. Now Trump must continue Obama's discretionary policies. Example 8. Transgenders in the military. From the time of George Washington until last year of Obama's presidency, men who castrated themselves or imagined that they were women did not serve in the military. Obama changed that in 2016 without the approval from Congress. Yet several judges in Washington, Baltimore, and Seattle mandated that Trump admit them into the military and continue a policy that never existed before 2016. Judge Marvin Garbus of Baltimore, a Bush appointee, even ruled that the Pentagon must pay for the surgery. Every president as commander-in-chief can determine military enlistment qualifications, but not Donald Trump. Number 9. Obama's teenage pregnancy program is in the Constitution. In June, a federal district judge in Washington, D.C., Ketanji Brown Jackson, ordered the Trump administration to continue doling out $800 million in grants to private organizations to prevent teen pregnancies. This program never existed in this form until Obama has proven ineffective. But it must continue. Why? Because a judge said so. Example 10, Obama now sets regulations on cars forever. In April, the Second Circuit Court of Appeals issued an injunction on the Department of Transportation. Its delay of penalties to automakers that didn't comply with Obama's added corporate average fuel economy standards. Obama dramatically expanded the penalty, and his decisions are now final, and Trump is not allowed to reverse them, according to a judge. There's 13 of these. Number 11, Trump must regulate drainage ditches. In 2015, Obama declared that seasonal runoffs and ponds in your backyard are now navigable waters subject to federal water regulations. Trump merely restored the common sense policy in place since 1980, defining navigable waters as, waters that actually transport commercial ships, not breeding grounds for mosquitoes. But Judge David Norton, a George W. Bush appointee, ruled that Trump must continue Obama's policy despite a Georgia judge finding the policy itself to be unconstitutional. Number 12, hot air. Trump must continue Obama's methane policies. Last year, Judge William Orrick, this is a left-winger for sure, ordered Trump to continue Obama's lawless legislation of allowing the Bureau of Land Management, BLM, to regulate the venting and flaring of methane from oil and gas production. This has been devastating to our burgeoning natural gas industry. No statute on the books could conceivably grant such authority to the BLM. Orrick is the same lawless Obama donor judge who declared a nationwide sanctuary policy attempting to block the Department of Justice from punishing sanctuary cities. And number 13, Obama regulated free speech of 3D gun blueprints. Trump must do the same. Obama's State Department dramatically expanded its authority under the Arms Export Control Act and international traffic in arms regulations to stop Americans from merely publishing CAD files of 3D gun prints. This is the First Amendment, not a gun issue. The Trump administration merely stopped regulating this particular activity, but Judge Robert Laskin ordered the Trump administration to block Cody Wilson from simply uploading a CAD file. Now, these are just the cases, writes Horowitz, off the top of my head. It is self-evident that unless the entire culture and scope of power of the judiciary is reformed wholesale, elections will no longer matter unless Democrats win. This is why Convention of States and Article 5, folks, are so crucial. And this is why I discussed this at length with Tom Coburn and Mark Meckler, leaders of the effort in the grassroots community, on Fox on Sunday night at 10 p.m. I hope you saw it. If not, I would encourage you to go on the Internet and take a look if it's there. But these judges are out of control, absolutely out of control. They've been out of control for decades. And Woodrow Wilson was right. If they can control the courts, then they don't really have to mess too much with this inconvenient Constitution with its separation of powers and different branches and federalism with the states and all the rest. If we can interpret the law, we can control the country. That's what Woodrow Wilson believed. Seems to be right. I'll be right back.